2018. So Justice Holdridge may not have as many gracious words for me after I take his name in vain a few times today, talking about some of these appellate court cases. Only kidding, I would never do anything like that. Just watch. So today we have 7 cases that we want to go through. And so what we have usually done is bring the lawyers who have dealt with those cases here to talk about the cases. But since we have 7 cases to get through today, I thought we'd maybe get away from that, and I will just talk about the cases today because I want to make sure to get through all of the holdings. On the other hand, I know who you are. I mean, I know that the lawyers who handle these cases are in the room. So I want you to, and I encourage you to, comment after I've done the case that you have handled, and to maybe even answer some of the questions from the audience that I'm going to be fumbling around about, because you, of course, know the cases way better than I do, and so I'll offer you that as a volunteer opportunity. So if you feel like you want to say something, or you feel like you want to answer one of the questions that has been placed, please just raise your hand and I'll call you down here and you can say your piece. And you can even disagree with me if that's what you want to do. I won't shut off the microphone, I promise. Okay? So let's get right into it because we do have several cases to deal with today. So the first case I want to talk about is the Bagwell case. The Bagwell case was decided in September of 2017 by the appellate court, and this is the case that involves the calculation of the average weekly wage under Section 10, and specifically the definition of concurrent employment under Section 10. So what we had here was a gentleman who, Mr. Bagwell, who alleged that not only was he working for the employer, which is Nestle's, he was also working as a pastor or a minister in his community church. And what Mr. Bagwell wanted to do is to add the wages that he was earning at Nestle's, which is the job in which he got hurt, to the wages that he was earning as a pastor to come up with a concurrent employment average weekly wage under Section 10. So everybody, I think, is familiar with Section 10 and how it works, specifically regarding average weekly wage and concurrent employment. So this is the part of Section 10 that's cited on this slide that deals with concurrent employment. So what it says is that when the employee is working concurrently with 2 or more employers and the respondent employer has knowledge of such employment prior to the injury, and that's the critical phrase that's going to be interpreted by the appellate court in this case, his wages from all such employers shall be considered as if earned from the employer liable for compensation. So as we all know, what you can do is you can add the concurrent employment together to come up with the average weekly wage. Now, it turns out that in this case, the real issue was not so much the average weekly wage, although that would have affected the TTD that Mr. Bagwell was entitled to and so forth. The real issue in this case was Mr. Bagwell wanted a wage differential in this case. And what he said was that my concurrent employment should be my pre-injury earnings for my wage differential purpose, right? The pre-injury earnings compared to the post-injury earnings is the calculation that we do for a wage differential. So right off the get-go here, the question is the Section 10 calculation the same as the pre-injury earnings calculation for wage differential purposes, right? My understanding has always been that those are 2 different calculations. But in this case, understand that what the appellate court is doing is interpreting the concurrent employment provision of Section 10 in relation to that wage differential calculation, not necessarily in relation to the average weekly wage as it relates to the TTD rate or to the maintenance rate or anything else, okay? So kind of a side issue, but an interesting issue nonetheless, that the appellate court is interpreting Section 10 to determine what those pre-injury wage differential earnings might be. Okay, does everybody understand the distinction? Great. Okay, so the commission found that the arbitrator had properly excluded the concurrent wages as a pastor in Mr. Bagwell's case, because the arbitrator found and the commission affirmed that the employer, although the employer knew that Mr. Bagwell was working as a pastor, didn't have knowledge that Mr. Bagwell was actually receiving wages or compensation for doing that job as a pastor or minister. And in fact, if you look at the case really closely, it's not even wages that he was actually getting from the church. It was actually some kind of housing allowance. So the church was paying a $600 housing allowance, that's what they called it, to Mr. Bagwell. So the dispositive question, as the appellate court tells us in this case, is whether the employer had knowledge of the petitioner's employment as a pastor prior to the work injury at issue, thereby allowing this concurrent employment calculation. Let's go back to Section 10, right? Section 10 says you got to have two things in order for there to be concurrent employment. You've got to have real employment, right? It's got to be defined as employment, and the employer has to have knowledge of that. So those are the two prongs of the concurrent employment test. And what the appellate court says in this case is that that knowledge that the employer must have is not only that the petitioner was working in that concurrent employment, but the employer must also have the knowledge that the petitioner was getting paid for it, okay? And the way the court reasons, the appellate court reasons themselves into that finding is that they take a look at the dictionary, right, like they've done in several cases that we've seen here before, and they say the dictionary definition of employment is working for wages, right? Working for money. That's what it means to be employed, and therefore it's not just enough that the employer have knowledge that a petitioner is working. The employer must have explicit, specific knowledge that the employee is working in concurrent employment for money, for wages, okay? Begs the question, do they need to know how much that is? Do they need to know the extent of it? This appellate court case doesn't necessarily answer that question, but the question that it does answer is that the employer has to know that the employee is working for money in order for the concurrent employment to apply. All right? Anybody have any questions about that? And yes? Well, the way the appellate court reasons it is they say that this is a statutory requirement, right? The respondent employer has knowledge of such employment, right? They go to the dictionary, the appellate court goes to the dictionary and says, employment means working for wages. So if the employer does not have knowledge that the petitioner is working for wages or compensation of some kind, then that's not knowledge of employment, because the definition of employment includes working for wages. Well, so the question is, what's the rationale behind that? Why would that be important? I don't know necessarily, other than I think the appellate court would say, look, what we're doing is statutory construction here. We're just looking at the statute and we're trying to construe the statute. Although if you read the case really closely, they say we're not applying a de novo standard here. What we're doing is saying the manifest way to the evidence supports the finding that the employer did not know that the petitioner was working for wages. So even though they're defining a part of the statute, they're not using the de novo standard as they might in some other statutory construction cases. This is a manifest weight case. So what the appellate court says is that the manifest weight does not support the finding that does support the finding that the employer did not know that the petitioner was working for wages, although they did know that he was working as a pastor. Well, yeah, so the question is, what's the rationale? And the answer is you're going to have to talk to the legislature about that one, because that's the requirement that they put in the act. Yes, Judge.
What happens if no line of cases
So I don't, so the judge's question is, you know, what, it isn't like a housing allowance compensation, isn't like, you know, other in-kind compensation nonetheless. And I think the appellate court would have said, yes, it was, except that this employer didn't know that that was happening, right? Didn't know that this petitioner was receiving this housing allowance from the church. And the petitioner said, well, wait a second, they knew I was really involved with my church. In fact, I had done a wedding at the plant. I had officiated in a wedding at the plant for people. He had done like Thanksgiving Day prayers at the plant where they would put him on the loudspeaker and he would do the prayer. He had organized you know, like fundraising events at the plant. So they knew he was working as a pastor, there's no doubt, or volunteering. They knew that he was being a pastor. They just didn't know that he was getting some type of compensation for it, and that's what this case hinged upon. It hinged upon that fact. Yes? So the question becomes whether, you know, this is some type of per se rule about ministers and pastors that can never be concurrent employment. I don't think so. And the reason being, of course, again, you know, I always fall back on this. It's a manifest weight case, right? It's about these particular circumstances.
But at the end of the case, they said, we say it's a manifest weight, but then they threw in the zinger of, even if it wasn't, we would still rule the same way.
Yeah, so you know, Mr. Scordino is absolutely right. So if you're as a petitioner's lawyer, you're looking to maybe distinguish this case. I think you can distinguish it on the basis of, you know, that it's a manifest weight case. All right? Yes, sir.
So if you're working for, like, you know, Walmart or Walgreens, and this is one of those situations where you, well, the court then looked at and said, well, who works for Walmart for free? Well, they look at that and say, well, they're working in a retail establishment in court, they're getting wages.
Yeah, so the question is, you know, should an employer be attributed some like presumptive knowledge that people who are working at commercial enterprises are working for pay? I think so. I mean, I think that would be a decent, reasonable argument to make, right? The problem with a pastor or minister is that, right, it could be different, right? He could have been, I suppose, volunteering as a minister or a pastor. In fact, the appellate court uses that word, that to the employer this looked like I think they call it a volunteer or community activity. So on the face of it, it didn't have the indicators that it was paid employment, I suppose. So Mr. Ruffalo says it's an obvious common sense rule, and since I lack common sense, I can neither agree or disagree with that. Yes, ma'am.
Dave, here's my hypothetical. I'm the employer, and I know that my employee is working somewhere else, and then he gets hurt. And the position I take is, well, yeah, I knew he was, let's say, driving a cab on the side, but I didn't know that he was an employee of the cab company because I didn't know that he met the control test. I thought he was an independent contractor. Therefore, I didn't have knowledge of his concurrent employment.
Yeah, so, you know, the idea is what if it looks like an independent contractor situation? Is that employment, and, you know, is that employment for pay? I think, again, because this is a manifest weight case, those kinds of issues are just going to have to be re-litigated. In other words, I hesitate to say that this is some kind of bright line rule with it being a manifest weight case, but be careful if you have a concurrent employment. You know, make sure you at least have some evidence that the employer knew that the person was working for pay. Even if you're relying on this kind of presumption that, look, when you work for Walmart, you don't volunteer at Walmart, right? I mean, so even if you're relying on some type of presumption or something, just make sure there's some argument that you can make. But, you know, again, in a maybe don't want to belabor this, but you got to realize this was also in the context of the wage differential. So it wasn't really even strictly a Section 10 calculation if the pre-injury wage differential employment is not a Section 10 calculation necessarily, and I think that that's pretty much the law, right? It's not necessarily a Section 10 calculation, although some of the Section 10 principles may apply. So it's doubly interesting for that reason. So I'm going to skip through Hitch because I want to get back to that and spend maybe a little additional time on it at the end. So I want to just quickly talk about the Edwards case. So the Edwards case has to do with when there is a corrected decision, okay, and filing a petition for review of an arbitrator's corrected decision and kind of the pitfalls we practitioners can get into when there is a corrected decision. So I just want to give you some dates here that you may want to jot down for Edwards, okay? August 29th, arbitrator decision comes out. It has to do with medical bills. It says the petitioner is entitled to payment of medical bills in the amount of $36,000 subject to the public aid lien. The public aid lien was $5,000. They had paid $5,000 on that $36,000 worth of bills, which is going to be an interesting discussion we're going to have at the end in the Perez case that we're going to talk about. But in any event, the respondent receives that decision on September 13th. Okay? On September 26th, the respondent files a motion for correction of a clerical error pursuant to Section 19F, so within the 15-day period for doing that under Section 19F, filed a motion for a correction of a clerical error, and the clerical error that the respondent is alleging is they say, hey, look, you're not clear about what we owe in terms of these medical bills. Do we owe the $36,000 that was awarded, or do we owe the $5,000 that public aid paid against that $36,000 worth of bills, because that's the public aid rate for that $36,000 worth of bills. A corrected decision comes down from the arbitrator on October 9th, okay, so a few weeks later, and says, oh yeah, no, what I meant was you've got to pay the public aid lien, right? You've got to pay the $5,000 against that $36,000 worth of bills. Again, we'll talk about Perez here in a few minutes, all right? On November 5th, the respondent files a petition for review, asking for a review of the decision of August 29th. Okay? So the petition for review filed timely, right, within 30 days of that October 9th corrected decision, but it refers to the August 29th original decision, right, which no longer exists because of the corrected decision on October 9th. All right, everybody understand the setup here?
Yep.
Okay? So this is a little different from these other cases that we've seen, right, where there's an original decision, I rush out and file a petition for review on that, right? My opponent files for a corrected decision, right? The corrected decision comes down, I don't file a petition for review on the corrected decision, and the 30 days runs, and I say, well, wait a second, I filed my petition for review off of that first decision. The case law is pretty clear under those circumstances, right? The case law says, hey, look, you filed a petition for review on a decision that no longer exists because of the corrected decision, okay? You're out of luck if you don't file a new petition for review on the corrected decision, even if you filed a petition for review on the original decision, right? Everybody understand that case law? That case law is pretty clear. This is a little different, right? This is a little different. In this case, the correction, the petition for review was filed within 30 days after the corrected decision, right? But it referred to the wrong decision. It referred to the original decision. And as harsh as this might sound, the appellate court said, therefore, no subject matter jurisdiction, right? Because the petition for review was not filed for the correct decision, right? And therefore, there was no petition for review filed for the corrected decision. You are out of luck. It's an extremely, extremely harsh rule. The respondent argued, hey, look, it was a Scrivener's error, right? It was a clerical error, right? I filed it within 30 days of the corrected decision. I knew the rule, right? I knew the rule that Manchetti just talked about, that you can't file on the original decision. You got to file on the corrected decision. I knew the rule, and I filed within 30 days. Just I put the wrong date on the petition, and it was a clerical error, right? I filed within 30 days. Everybody knew what I meant to, what I wanted the commission to review. I wanted them to review that corrected decision. The appellate court says, yeah, it's not a typographical or Scrivener's error, because it's not just, transposing a couple of the numbers or, saying it's 2017 instead of 2018. It's, you picked the wrong date. It's the wrong date, all right? An extremely, extremely harsh rule. So when we come across these extremely harsh rules as practitioners, what do? We change our underwear, maybe, but I'm sorry to be gross. But what we also do is we learn a lesson, right? You proofread your petitions for review 100 times if you need to before you file them, okay? Don't wait for the last minute to file your petitions for review, because if you do, you might be making an error that you're later going to say, in my rush, was a Scrivener's error, but in fact, the appellate court's going to say, yeah, not so much. Okay? So, extremely harsh rules should make us all a lot more careful. And I'm sure that that's what we're going to do. So, Joyner is a case that has to do with attorney's fees, an issue that is near and dear to our heart. So let's try and set this up. Petitioner settles a third-party case, right? For some of a lot of money. Okay. He then says, I want to settle my workers' compensation case for $1 and waiver of the lien. The problem is that by doing that, what he's going to do is he's going to cut his workers' compensation lawyers out of a fee, right? Because what's the fee on $1, right? 20 cents, I suppose, right? So what this case stands for is the proposition that if a workers' compensation lawyer has engaged in some work, even gotten some type of settlement proposals to settle the case, that the workers' compensation lawyer is entitled to receive compensation for his work or her work, even if the petitioner settles the case, the underlying PI case for $1 and a waiver of the lien. And it turned out that the procedural history is a little complicated because it turned on what a particular settlement contract said and what particular promises the petitioner made to pay attorney's fees when the arbitrator approved the contract, and later when the commission made the award of attorney's fees. But suffice it to say that this case, and we need to thank Fran for handling this case, because it proves to those bully PI lawyers that we're not going to go uncompensated for the many, many hours and weeks and months of work that we do. So thank you, Fran, for doing this case. So there's a couple of interesting things here, though, about this case, too, right? So one of the claimant's arguments in this case, the guy who was going to have to pay the fee, one of his arguments was, hey, look, if the petitioner's lawyers wanted a fee, they should have sued him. They should have sued the petitioner in circuit court, right? That's where you sue on contracts, right? What the appellate court says is no way. That attorney's fees in workers' compensation cases are the exclusive purview of the Workers' Compensation Commission. Okay, exclusive. You can't be suing your clients in circuit court. You got to resolve your attorney's fees issues here at the commission, and I think that's a really, really important ruling. The other interesting part of this case is that the person against whom the award for attorney's fees was made by the commission forgot to file a bond in the case. And so here's a little statutory construction, right? The appeal bond applies to entities which, entities against who compensation is awarded, right? And what the appellate court says here is that even though this guy wasn't, a petitioner or a respondent, right, in this particular proceeding, that he's a person against whom an award has been made and therefore needed to file a bond. So when he didn't file a bond, the appellate court, lacked subject matter jurisdiction in the case. But in any event, they resolved some of these issues even though they lacked subject matter jurisdiction. And that's really great because now we have this case that says, look, attorney's fees have to be resolved here at the commission, and you can't just stiff your workers' compensation lawyer on a $1 settlement contract and waiver the lien.
How do they square that with the SPZO?
Well, I think, so Frank says, Sam says, how do they square that with the Esposito decisions? And I think the Esposito decisions have to do with referral fees, right? So I think what the appellate court said in that case was that referral fees are not really fees that fall under the provision of Section 16A. So I think that's how they made the distinction. I'm not sure I agree with that distinction, but I think that was the distinction that was made. All right? Okay, so let's, Fran, you want to say anything about this?
I just want to thank also Rachel Sastry for helping with this one. And she also
So Rachel Sastrin helped with it too, and
together, but it was a complicated case because of the statutory construction issues with respect to subject matter jurisdiction and the jurisdiction of, the appellate court and also the commission. I think that also kudos to arbitrator Kane, who had a hearing on the record and went the entire way with us on this one and listened to the arguments and made the appropriate award.
Right. So, per usual, Rachel did all the work and Ellis took all the credit, right? So that's how this one worked too. So. I'm only kidding. Is Ellis here? Okay. Good. All right. So, you look in the decision. Prairie Farms Dairy case. So this is a case that is an unreported decision. And I know I'm not supposed to talk about unreported decisions because I'm going to get unpublished decision. I'm going to get criticized for doing this. But I think it's a really, really important case that maybe should have been published. So we talked last year a lot about 8.1b cases, right? The AMA impairment rating cases. We talked about Corn Belt. We talked about flexible staffing. All those really important cases. Well, here's another case in a line of those cases that says that, look, when the legislature instructed the commission to explain and weigh the 5 factors of 8.1b, okay, the legislature wasn't kidding, right? They wanted the arbitrators and commissioners to explain and weigh the factors of 8.1b, the 5 factors, including the AMA impairment rating. So in this case, what the commission had done was they affirmed and adopted all of the arbitrators' findings. They made a few additional findings of their own, and they modified down, they reduced the award that the arbitrator had made from 22.5% of the leg, and I think I have 2% here. No, 22.5 of the leg down to 15% of the leg. And that was based on a 2% AMA impairment rating and all of the other factors. So the petitioner says, hey, wait a second. You took some money out of my pocket. I want to know why you did it. And he takes the case all the way to the appellate court on that issue. And the appellate court, lo and behold, says, look, commission, when you modify down like that, you have to explain why you're modifying down. You have to tell us which of the factors you weighed, which of the factors you thought were important, which of the factors you thought were important in reducing the award. And if you don't do that, what we're going to do is we're going to remand the case. Case goes all the way up to the appellate court, right, to be remanded back down to the commission to have a full and complete explanation of the 5 factors and the weight that they're given, okay? So, again, practical tip here, when you're doing a proposed decision for an arbitrator, if you want the arbitrator to find your proposed decision to be persuasive, do a complete analysis of each of the factors. You know, we've talked about how that works, right? The age, you know, you're older, therefore you're going to live with the disability a little less. You're younger, you're going to live with it longer. You know, future earnings, you didn't return to your real job, and even though they can't necessarily be calculated, that's significant. You know, AMA impairment ratings are not disability. The AMA impairment rater was not certified to do the AMA impairment rating. All of those kinds of things that we've talked about a million times before, make sure those are in your proposed decisions so that you don't find yourself in the appellate court with the appellate court saying, hey, it wasn't explained well enough, start all over again. All right? So I think an important case under those circumstances. Anybody, any questions? Yes.
It already in section 19 that any time the commission modifies an order of arbitration that they must explain the reasons therefore.
Even more so. So Mark says it's already incumbent upon the commission to do that under section 19. So even more reason to have done it. Although this one was specifically about 8.1B. Okay? So an unpublished decision, but I think an important one because, again, you don't want to find yourself standing in the appellate court with Justice Holdridge saying you're going back down to the commission to start all over. So, Cisco Food Service is a case that involves the authority of the circuit court when it remands cases back to the commission. Okay, so this is a case where the circuit court judge in Cook County remanded the case to the commission, and what the appellate court answered in this case was whether the circuit court judge had the specific statutory authority to do so, whether he had the power to do that, to send the case back to the commission. So just really quickly, let's all remind ourselves what section 19F2 of the Act says, which is the part of the Act that says this is what the circuit court can do when a case gets up to the circuit court. The court may confirm or set aside the decision of the commission, period, right? Everybody got that? The court may confirm or set aside the decision of the commission. 2 choices, confirm or set aside. If the decision is set aside, so option number 2, if the decision is set aside and the facts found in the proceedings before the commission are sufficient, the court may enter such decision as is justified by the law. So if that circuit court says, I'm reversing, but I got enough facts here to work with, and I'm going to make my own decision based on those facts, then the circuit court can do that. But that's only if it's already set aside the decision, right? Or may remand the cause to the commission for further proceedings and may state the questions requiring further hearing and give such other instructions as may be proper. Okay? Set aside and remand, all right? Which is what the circuit court did here, right? The circuit court said, look, the award that the commission made of, I think, 30 of a leg or 30 of a leg is contrary to the manifest weight of the evidence because the commission ignored some evidence from the treating doctor, and instead I, circuit court judge, find that this petitioner is entitled to a wage differential. But I don't have enough information to work with on the wage differential to make that finding as to what that wage differential is going to be. So I'm going to remand it down to the commission for that part of it to come up with the wage differential. Commission says, look, we disagree that, you know, we thought we made the right decision first, but you're telling us we didn't, so here's your wage differential. That goes up again to the circuit court, gets bounced back down, goes up again. The procedural history gets a little complicated, but at the end of the day, the case gets in front of the appellate court. And what the appellate court says is that in this case, under these circumstances, that circuit court judge should never have remanded the case back to the commission for that wage differential in the first place, right? The appellate court does not agree that the commission ignored evidence, or at least says that you can't draw that conclusion from the decision. And even if they did, there's still enough evidence in this decision to support that original decision of 30% of the rate. So, what does this case tell us? This case tells us that when a case is remanded from the circuit court, make sure that it's proper that it's being remanded to the circuit court, because otherwise, you could run into some situations where maybe that decision becomes final and you haven't filed a notice of appeal on that. So just be really, really careful about these circumstances, especially where you have some opportunity to help that circuit court judge draft that order, right? I mean, perhaps when the circuit court judges are asking for our help to draft that order, we should use the language specifically from 19F2, right? I set aside and the 30% loss of use of the lake based on it being contrary to the manifest weight of the evidence, and I remand to the commission specifically for this particular reason, because I don't have enough facts to make that decision on my own. Would that have made any difference in this case? I don't know, maybe, maybe not, but I think it would have given maybe a little more solid footing, okay? All right, everybody understand this one? Okay, good. This one's a little technical, but I think there's an important point to be drawn in this case. So before we go back and circle back on Dukic, I want to just talk about this Perez case. So this Perez case came down about 2 weeks ago, okay? But it's a really, really important case that we've been waiting for an answer from the appellate court for many, many years now, ever since the Tower Automotive case. Everybody remember the Tower Automotive case that we talked about here, which is, what if somebody else pays the medical bills, right? What if somebody other than the respondent pays the medical bills? What is the respondent required to pay? Is it required to pay what that third party paid for the medical bills? Or is it required to pay what the medical fee schedule would say that those bills are? Because more often than not, there's a difference, right? When a third party pays the medical bills, more often than not, there's some kind of discount, or there's some type of, rebate, or, whatever they call it, whereby the rate that is being paid is less than what the fee schedule might be. In a situation where that happens, we thought that Tower Automotive told us that, well, maybe it should really be what the medical fee schedule is. In any event, nobody was quite sure exactly what Tower Automotive told us, but now we should be sure, okay? Because what the Perez case says pretty clearly is that when a third party pays the medical bills, that is the negotiated rate for purposes of Section 8A of the Workers' Compensation. All right, does everybody know what I'm talking about here? All right, so this is not an HA situation. This is not a situation where the petitioner's own health insurance paid the bills, right, and the respondent is going to get a credit for what the HA payment was, right? This was one of those situations that we see where the petitioner's husband's health insurance paid the medical bills. And the rate that the husband's health insurance had was lower than the medical fee schedule, right? And so the question becomes, does the petitioner get the medical fee schedule, or does the petitioner get, and does the respondent get the benefit of that lower rate that's been negotiated by the non-HA husband's health insurance. And what Perez says is that, yes, it does, right? Because otherwise, it's a windfall to the petitioner, right? Because if you award more than what the husband's health insurance paid, the wife pays back the husband's health insurance and pockets the difference, okay? And so the appellate court said that as a matter of law, right, statutory construction, the negotiated rate is the rate at which that third-party payer has paid the medical bills. And just so everybody remembers, what Section 8A says is that the employer shall provide and pay the negotiated rate if applicable, or the right? So if there's a negotiated rate, that's what gets paid. And what the appellate court is telling us is that the husband's health insurance rate is the negotiated rate for purposes of Section 8A. Okay? Really important case that we've been waiting for the answer to. So to go back to the case we talked about earlier, right? That public aid rate, right? The $5,000 on $36,000 worth of bills. Does Perez apply to that? I think so, right? I think so, right? Yes.
Section Medicare pays their negotiated rate also, so that the employer will only have to pay the severely discounted Medicare.
So Mr. Scordino's point is, what about Medicare? Sure, just like Medicaid, right? Does Perez apply to Medicare? I think so. So basically what Perez does is, we used to think that there was kind of a quasi-collateral source rule over here at the Workers' Compensation Commission, right? But, no such thing now, right? Now the collateral source rule blown out of the water by the Perez case, at least as far as workers' compensation cases go. Yes? So Mr. Casey's question is, isn't this setting it up so that the employer has some incentive not to pay the bills to see if they can get the husband's health insurance to pay so that they can take advantage of that rate? Yeah? Yes? But don't forget, there's exposure penalties in that case. If you could ever get a respondent to admit that, like, yeah, we owe the bills, but let's see if we can get these guys to pay it so we can take advantage of that rate, I think that'd be a pretty good penalty. So, yes?
There's a practical solution to that. Technical one. What they do when they bill group and/or Medicare and Medicaid is they put bold letters on the top of the bill. Workers' compensation ended. What that does is it allows the doctor to reimburse Medicare, Medicaid group when they collect the workers' compensation.
So Sam says that the doctors are way ahead of us on this one, right? They already have developed a procedure by which they can kind of put the group care, the health insurance, whatever that is, Medicare, Medicaid, kind of on notice, right? But keep the workers' compensation aspect of it pending. Yes?
In a disputed case, do you think that the attorney is entitled to, under the common fund, to get a fee on some covered medical?
So here's a question. What about attorney's fees on this, right? How do attorney's fees work on the Perez case? Anybody care to guess? Because I talked to Arbitrator Hipsch about this, and being the greedy petitioner's lawyer that I am, that's where my mind first went. How to get a fee on this, But I don't know. I haven't figured that quite out yet, right? I mean, anybody got some suggestions on that?
Well, I think
Why would the attorney not be entitled to a fee?
Okay, so why is the attorney not entitled to a fee, Mark says? Well, because that third-party payer says, who are you? I mean, what do you mean?
Well, someone has to be paid back.
Pay us our money back,
In
right?
other words, the
CMS
bid,
is not going to give you a discount because the workers' comp.
well, yes, but the amount of money paid by the group is going to be awarded to the petitioner. I mean, there's no free lunch for the employer here. I mean, they have to pay something.
So
We may not like what they pay, but they have to pay.
well, Mark, but we petitioners lawyers get into trouble when we stiff the people that are clients for money for medical bills.
No
We
sniffing
get
them
into
out.
big trouble under
No
those
sniffing
circumstances.
them out. All I'm saying is that the
But-
attorneys have to be entitled to fees, they recover the money.
But how do I approach that health insurance carrier and say, health insurance carrier, you paid $5,000, but you're only going to You want to come and make that argument? Good.
I've done it. I've done it for you.
I know.
I've done it for
I know.
you.
Yes.
What about the situation where a doctor actually gets paid by one of these third-party payers and then decides to pay them back when they realize it's workers' comp?
Yeah, what about when the doctor says, oh, you won that workers' comp case? Here, health insurance payer, here's your money back, where's my workers' comp payment, right? They're in a breach of their contract with that health insurance carrier when they do that, and they don't want to screw up their contract with Blue Cross Blue Shield by doing that. Okay, so if you ever run into that, remind that doctor that that's the case. That doctor, you're in breach. Because when you take money from Blue Cross Blue Shield, in the Blue Cross Blue Shield contract, it says, that's all you can ever get, doctor. Don't go asking that injured worker for more money. Don't do it. Yes.
Okay, just one caveat about that. When you're doing a fee schedule analysis and a Blue Cross Blue Shield analysis, sometimes the Blue Cross will pay more than the fee schedule, sometimes they'll pay less. So for each procedure, you have to look at the code, because you could have Blue Cross paying a lot more than the fee schedule, and the award should only be pursuant to the statute, which is the negotiated rate or fee schedule, whichever is less.
So Grant says, be careful because, sometimes the Blue Cross Blue Shield payment is actually more than the fee schedule. So just be careful that you're making sure that, you got the right number. Okay, all right, so, yes?
Third party works, you want to get the health insurance carrier and Medicaid carrier, what they're leaning by a third on the equitable fund doctrine, which would be theirs third. Why couldn't you argue the equitable fund doctrine here?
So, look, I've been told time and time again that there are whistle rules that apply to these things. There's a bunch, there's federal preemption issues. This is not as easy an issue as just saying, I created a fund, therefore I'm entitled to a fee. There's federal law issues, there's fiduciary issues, there's a whole bunch of issues that frankly just make me nervous, right? So maybe I'm a little too nervous, but they make me nervous. All right, so let's take the few remaining minutes we have to talk about linkage, which is a case that is near and dear to my heart because it's my office that represented the commissioner in this case. So, sorry, put on your petition. Okay, so what are the facts in Duke? Okay, the facts in Duke are that Barbara Duke was working for Fenton Community High School, and one day on her lunch hour, she decided to leave the building to go home for lunch, which she was allowed to do. And as she walked out of the building, within a few feet of the doorway, I mean literally inches from the doorway, she slipped and fell on the walkway that she was on as she was going to her assigned parking space. Okay, it's into her assigned parking. I thought you were going to cut me off. So, to her assigned parking space in the parking lot that was provided to her by the employer. So she's on the walkway, not in the parking lot, she's on the walkway within feet of the threshold of the door of the school. On the outside, she notices that it's raining, and so she decides that she's going to go to her car. As she's going to her car, every decision maker who has decided this case says, sometimes they use a different word, but every decision maker at least once has used the word that she slipped on the water, the wet pavement that was wet because of the rain that was falling. She sustains a concussion and an injury to her shoulder. So the high school denies Ms. Dugich payment of benefits, and the case is tried in front of the arbitrator. The arbitrator decides the case on this basis, and this is the arbitrator's decision, which I have here on this slide. So first of all, in the person part, right, the part where she was going to lunch, all right, the part where she was not maybe working at the time, right? In the course of was not disputed, right? The in the course of was not disputed. It's based on this idea that we have, right? That you got this kind of little zone of safety around your workplace, right? You kind of got a little time and a little space to get in and out of your work area, right? So in the course of was not in dispute in this case. This is strictly an arising out of case. So the question is that wet pavement that was made wet on which Barbara Dukic slipped by rainwater considered to be arising out of the employment, right? Is that an arising out of issue? And what the arbitrator in this case said was that, sure, it's an arising out of case. And the reason why it's an arising out of case is because it's connected to the employment, right? It's associated with the employment. The condition of the employer's premises, which no doubt these were, because that in the course of was not disputed, the condition of the employer's premises is always associated with or connected to the employment. So of those three risks that we know about, what the arbitrator decided was that this was an employment risk, right? It was an employment risk because it was the condition of the premises, wet pavement, that caused Barbara Dukic to slip and fall, all right? Three different types of risks, right, that we've talked about a lot. Personal risk, never compensable, right? Strictly related to the petitioner herself, never compensable. Employment risk, always compensable, right? Associated with or connected to the employment, the kind that the arbitrator found here because it was the condition of the premises that caused her to fall. Or neutral risk, sometimes compensable, sometimes not compensable. Okay? The arbitrator found that this was an employment-related risk. Went on to say, yeah, but even if it's a neutral risk, it's a risk greater than the general public because she's got to traverse that area and so forth. But clearly, the arbitrator found employment risk, kind of backup plan, neutral risk, but employment-related risk, you don't need neutral risk. Right? Case goes to the commission, and the commission says no way. Right? The commission reverses the arbitrator's decision and says this. Right? First of all, it says walkway wasn't defective. Okay, there wasn't any pothole, there wasn't any crack, there wasn't any gap. Right? The walkway was not defective, even though there was an incline. Right? Everybody, talked about there being an incline in this, walkway. And remember that case we talked about a few years ago, the Metropolitan Water Reclamation District, where the woman is going to the bank, right? And she trips on the handicap ramp, right? And that's considered compensable, right? Apparently not so for Ms. Dukic, even though this was a ramp. There's no accumulation of ice or snow, right? Is what the commission was saying. Okay, you're right. It wasn't ice or snow. It was water, which I think is what ice and snow is when it's frozen. Okay? I think the chemical, if I'm remembering correctly from high school chemistry, H2O, I think that applies even when it's snow or ice. Okay? But the commission found that the petitioner was not subject to a risk greater than the general public, because even though that walkway was wet and slippery, okay, it was wet and slippery for everyone, right, who was walking out in the rain on that day, okay? But the commission makes a distinction because of what it says here between rainwater and ice or snow, right? So the commission says is that no increased risk, right? Therefore, it's a personal risk. The commission actually finds that the risk was personal to Ms. Dukic, okay? So we appealed that decision to the circuit court. The circuit court confirmed the commission's decision, and the case gets to the appellate court. So the petitioner's argument in the case in the appellate court was, first of all, look, this is de novo jurisdiction for the appellate court. This isn't a manifest way case. Why? Because the facts are undisputed in this case. Everybody agrees that it was wet. The word slipped was used by every single decision maker in the case. The petitioner's history was of slipping. The ambulance report said slipped. Everything said slipped, right? It's undisputed. You know how else we know that it's undisputed? The accident was videotaped, right? The security camera of the school caught Ms. Dukic falling, and that was admitted into evidence. So the appellate court got to witness this accident. The facts were right there before them in black and white or color. By the way, a practice tip here is that the appellate court, when they took the case under deliberation after the oral arguments, asked for 5 copies of the videotape. And we were told that if you want the appellate court to look at a videotape, you should put that as the appendix in your brief, okay, so that each one of them has a copy. Otherwise, there's only one copy floating around, and they have to kind of share it, and if it's there in the record to begin with. So practice tip is, if you want the appellate court to look at a videotape, you know, add it to your appendix. So the appellate court says, no way, this isn't a de novo case, right? It's a manifest way case, and the reason why it's a manifest way case is that even though the facts may be undisputed, the inferences from those facts can be disputed, okay? I've never quite understood this argument, how, you know, something can be undisputed and disputed at the same time, but nonetheless, that's what the appellate court is telling us. The appellate court agrees with the commission on a manifest weight standard, right? This is a manifest weight case, according to the commission, that the case is not compensable. And the court says that the dangers created by rainfall are dangers to which all members of the public are exposed on a regular basis. Okay, that's one of the findings of the appellate court in this case. So they recognize that rainfall can be a danger, right? The dangers of rainfall, right? How are the dangers of rainfall different from the dangers of ice, or the dangers of snow, okay, or the dangers of coffee, or the dangers of pop that has been spilled on the floor, okay? But nonetheless, that's what the appellate court says here. The appellate court says that it should be a neutral risk case, not a personal risk case, and the reason why it's a neutral risk case is because everybody at some point in their life has to walk on wet pavement. That's not anything that is peculiar to this employment. Except that, of course, the condition of the employer's premises is always peculiar to the employment, right? It's literally connected to the employment, right? The premises are literally connected to the employment. So as you can see here, I'm no big fan of this appellate court decision. The other, just before we go and take some questions, the other important sentence I think here is this one in this next bullet point, the first sentence. The wet pavement upon which the claimant fell was no different from any other wet pavement. Yes, my point exactly, right? So just because it was wet from rainfall doesn't make it different from being wet from melting ice or wet from melting snow, right? The wet pavement upon which the claimant fell was no different from any other wet pavement. Absolutely right, and yet the appellate court uses that as a reason to say this case is not compensable. So, any comments from the lawyers? Mark, any? Yes, I see. Hold on, sir. I see a lawyer who is familiar with this case. So what Kelly brings up, right, is that they didn't stipulate that she slipped, right? No doubt about it. That's what this dispute, that's what this case was all about. That she slipped, right? But every decision maker in this case says she slipped, right? But it doesn't matter that she slipped because it's on rainwater as opposed to being on ice or on snow. Or, for that matter, rainwater that has been tracked inside the building, right? Right? The Tribune case, right? Rainwater that has been tracked inside the building. What's the difference between rainwater inside the building and rainwater outside the building if there's no dispute about in the course of, right? What's the difference? And Arbitrator Andros says it's because the commission says so. Unfortunately, now the appellate court says so too. So yes, Mark.
It's almost as if the court is introducing the tort concept of distinguishing between natural and unnatural accumulation, which was never, to my recollection, a workers' comp.
So Mark brings up this idea that maybe the appellate court is introducing some, negligence standard or some fault standard into this system. In fact, I can tell you that was at least apparently on the mind of at least one of the appellate court justices who asked the lawyer in our office who argued the case, but what could the employer have done to prevent this accident, right? And our lawyer, to his credit, answered the question politely, because I don't think I would have been so polite answering the question. And our lawyer said, well, of course, that's irrelevant to this discussion, but if you're asking me the question, I'll answer the question. They could have built a cover over this walkway to prevent the rainwater from getting the walkway wet. If that's what you're asking me, what could they have done? That's what they could have done. And that justice said, well, but that's expensive, and they couldn't really do that. They're a high school, and blah, 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 blah. And our lawyer kept arguing his point to this justice, and the justice finally said to our lawyer, this line of discussion is ridiculous. And our lawyer said, yes, it is. Okay? So is it, in my opinion, is it ridiculous to be talking about fault concepts in a workers' compensation? Yes, it is ridiculous. Yes?
Was this in the employer owned parking lot? Like, was this an employee-only
No.
parking lot or
So,
a public parking lot?
It's a parking lot where she was assigned a parking space, but it's not, but this accident didn't happen in the parking lot. It happened on a walkway leading to the parking lot in an area that was admittedly owned, controlled, managed, maintained by the respondent within feet of the door. I mean, within feet of the doorway. So not out in the parking lot. And by the way, what difference does it make when there's no dispute over in the course of, right? She was in the course of her employment when this happened.
My other question is, did anyone note what the temperature was that day? Or what, like, anything about the rain turning into ice or anything of that nature?
It was raining, right? It wasn't one of those days like today where the snow is falling, but when it hits the ground, it turns into water as opposed to, right? So take those circumstances. What if this was snow that was falling that didn't stick, as we say in Chicago, right? It's not sticky, right? And turned into water as soon as it hit the ground. Would that be different than rainwater falling? What if the employer had built a cover over this walkway and there was a hole in the cover and the rainwater was coming through the hole to make this walkway wet? Would that have made a difference? Your guess is as good as mine. Yes?
If you had to do over, would you consider hiring a construction expert to say that?
If we had it to do over, we wouldn't have taken the case.